Imagine standing in a courtroom, looking a judge dead in the eye, and telling them that you are 100% innocent of the crime you're accused of.
Right, you're saying you absolutely didn't do it.
Exactly. You didn't do it. But then, in the exact same breath, you officially plead guilty to that very crime.
It sounds like a total glitch in the legal matrix, honestly.
It totally defies
Yeah.
common sense.
Yeah.
And imagine the highest court in the land looking at that bizarre contradiction and saying, yeah, that is perfectly constitutional.
It shatters basically everything you think you know about how justice works,
It really does. Welcome to the Deep Dive, everyone. If you are joining us today, you are probably what we like to call the learner.
Yeah, you're someone who wants to understand the hidden mechanics of the world.
Exactly. And today, we are talking directly to those of you who might be staring down the barrel of the multi-state bar examination.
The infamous MBE.
The very same. Or really, anyone who just has an intense curiosity about how fundamental legal rights actually operate in the real world.
Because our mission today is to completely demystify the constitutional standards for criminal trials and guilty pleas.
Right. We are looking at the source material that serves as, well, the ultimate boundary line for the state.
Yeah, we often think of the government as this unstoppable machine, but in the realm of criminal law, the Constitution forces that machine to navigate a very precise, highly regulated labyrinth.
And if they step out of bounds, the whole case can just collapse.
Exactly. So we're taking these dense, intimidating rules and translating them into clear, simple English.
We're focusing on the mechanics, how and why these rules work, rather than just throwing a bunch of legalese at you.
And because so many of you are listening to this as prep for the bar exam, we are going to do something highly practical today.
Yeah, we aren't just going to lecture. We are going to organically recap the absolute need-to-know rules as we go.
Think of it as building a mental cheat sheet in real time.
I love that. Okay, let's unpack this. We have this massive rule book, but before we even get to the dramatic courtroom scenes, we have to figure out who is actually allowed into the courtroom.
Right, because there's this massive myth out there that if you get arrested for anything, you automatically get a jury of your peers.
It's a myth perpetuated by basically every legal drama on television.
TV loves a jury. It's great drama. But the reality is that the Constitution, specifically the Sixth Amendment for federal cases and the 14th for states, is much more selective.
You're only guaranteed a jury trial for what the law defines as serious or non-petty offenses.
Exactly.
Okay, non-petty. But how on earth do we define that? I mean, if someone steals my car, that feels pretty serious to me.
Sure, of course it does.
But if they steal my bicycle, maybe that's petty. Is it based on the financial value or the moral outrage?
It actually has nothing to do with the facts of the specific crime or how the victim feels about it.
Oh.
Yeah, the Supreme Court drew a hard, objective mathematical line in the sand. The rule is strictly based on the authorized statutory sentence.
Wait, break that down for me.
So a non-petty offense is any crime that carries an authorized maximum sentence of more than 6 months of imprisonment.
More than 6 months. So exactly 6 months and 1 day.
Precisely. If the legislative statute for the crime you're charged with says the max possible sentence is 6 months, you do not have a constitutional right to a jury.
The judge handles it alone.
Right. But if the statute says 6 months and 1 day, or a year, or life in prison, you get a jury.
You know, I love to think of this 6-month mark as a constitutional bouncer at an exclusive nightclub.
A constitutional bouncer, I like that.
Yeah, so you walk up to the velvet rope, and the bouncer asks, what is the maximum statutory sentence for your crime?
And if you say 6 months,
The bouncer shakes his head, unclips the rope, and points you to a side door that just says, Judge.
you only get into the main club with the jury if you can say more than 6 months. That bouncer analogy works perfectly because the bouncer doesn't care what you actually end up drinking in the club, just like the law doesn't care what your actual sentence ends up being.
Right, we are looking strictly at the authorized sentence.
Yeah, the judge could end up being incredibly lenient and sentencing you to just 1 week in jail, or even just a fine.
But if the statute allowed for a year, you were constitutionally entitled to that jury trial, regardless of the final outcome.
Exactly.
But wait, let me push back on that bouncer for a second. What if a crime is punishable by exactly 6 months of imprisonment, but there are a bunch of other nasty penalties attached to it?
Like what?
Like, say, a $10,000 fine or 5 years of really strict probation. Does that aggregate severity somehow magically transform a petty offense into a non-petty one?
As a general rule, no. The Supreme Court has looked at cases just like that, 6 months in prison plus massive fines and years of probation.
And what did they say?
I said, nope, that is still a petty offense. Those additional statutory penalties have to be unbelievably severe to tip the scales.
Wow. So for all intents and purposes, especially if you were analyzing a fact pattern on an exam, that more than 6 months rule is the gold standard.
Absolutely.
Okay, so more than 6 months is the magic number. But this leads me to a scenario that feels like a massive legal trap.
The aggregation trap.
Yes, let's talk about the aggregation trap. Let's say I have a really bad week. I commit 5 separate petty offenses.
Okay, lay it out.
I shoplift a candy bar, I trespass in a park after dark, I jaywalk in front of a cop, I loiter, and I spray paint a wall.
That is a very bad week.
Right. Let's say each of those petty offenses carries a maximum sentence of 3 months in jail. 3 times 5 is 15 months.
Which is way more than 6 months.
Exactly. I'm facing over a year behind bars. Do I get a jury now?
You still do not get a jury. You are kept outside the club.
Wait, really?
Yes, this is a crucial, highly testable distinction. There is no right to a trial by jury for multiple petty offenses, even if the combined stacked total exceeds 6 months.
So I could be sent to a concrete cell for over a year by a single judge without ever seeing a jury of my peers.
Yes, because the prison terms for those individual convictions are not aggregated. They are not added together.
So the court just looks at each offense in a vacuum.
Exactly. 3 months. Petty.
Yeah.
3 months. Petty. It simply doesn't matter if you have 100 of them lined up.
That is a brutal reality check, but a very clean rule to remember.
It is.
Okay, let's talk about the one weird exception to this math. Contempt of court.
Ah, yes. The classic movie scene.
Right. You always see scenes where a lawyer yells at a judge, and the judge bangs a gavel and yells, 30 days in jail for contempt.
Right.
How does the 6-month rule apply when there isn't a specific criminal statute written by a legislature?
Well, contempt is a unique beast, and to understand it, we have to split it into 2 completely different categories: civil contempt and criminal contempt.
Okay, let's start with civil. What is the mechanism there?
With civil contempt, the primary goal of the judge isn't to punish you for being bad. It is to force you to comply with a court order.
Like what, for example?
Imagine a judge orders you to hand over a specific hard drive, and you refuse. The judge holds you in civil contempt and locks you in a cell.
Okay, so I'm in jail.
But here is the mechanism that matters. You hold the keys to your own cell. The very second you agree to hand over the hard drive, you are free.
Oh, I see. Because you can avoid the punishment entirely just by complying, there is never a jury trial requirement for civil contempt.
Exactly. That makes logical sense, right? You are in control.
But criminal contempt is different, right?
Right.
That's when the judge is actively punishing you for disrespecting the process.
Right. Criminal contempt is purely punitive. You can't undo it by complying later.
But here's the problem. Often, there is no legislatively authorized maximum punishment for criminal contempt.
Exactly. The judge just decides the penalty right there on the spot. So our 6-month rule suddenly hits a wall.
Yeah, the bouncer doesn't have a list to check. So what do?
In cases of criminal contempt where there is no statutory max, the right to a jury trial is determined by the actual penalty imposed.
Wait, so this is the big exception to the authorized sentence rule we just talked about?
Yes. If the judge actually sentences you to over 6 months in jail for criminal contempt, then retroactively you should have had a jury trial.
But that's a total paradox. How do you know if you are entitled to a jury trial until after the judge has already sentenced you without one?
It is absolutely a paradox. The system essentially gambles.
Gambles how?
If an alleged contemner is facing a hearing, they are not entitled to a jury just because there is a theoretical possibility the judge might give them a year.
So the hearing proceeds without a jury.
Right. But if the judge loses their temper and actually hands down a sentence of 9 months, that conviction instantly becomes constitutionally vulnerable.
Because the judge crossed the 6-month line without a jury. So does the whole conviction get thrown out? Do they have to start over?
Not necessarily, and this is where appellate courts get very pragmatic.
Okay, what do they do?
If a trial judge hands down a 9-month sentence for criminal contempt without a jury, an appellate court can simply swoop in, review the case, and artificially reduce that sentence to exactly 6 months.
You're kidding. They just trim it down to make it constitutional.
Yes. By dropping the sentence to 6 months or less, the constitutional attack completely vanishes. The problem is solved retroactively.
That is wild. It's like rewriting history to fit the rule book.
It really is.
Okay, one more scenario before we lock this section in. We've talked extensively about when you can demand a jury. But what if a defendant actively doesn't want a jury?
That happens more often than you'd think.
Right. Let's say I'm accused of a highly technical, boring financial crime that I think a jury will completely misunderstand.
Or maybe a crime so sensationalized in the media that 12 people off the street will be incredibly biased.
Exactly. I think a judge who understands the law would be much fairer. Can I just waive my right to a jury?
You can certainly try to waive your right and opt for what is called a bench trial, where the judge alone decides the facts and your guilt.
Okay.
But that waiver must be freely and intelligently made. You have to understand exactly what you are giving up.
So if I make that intelligent waiver, I have an absolute constitutional right to demand a bench trial.
No. And this is a massive pitfall for the MBE. You have a constitutional right to a jury trial. You do not have a constitutional right to a bench trial.
Wait, so I can beg for a bench trial and the system can just say no?
Exactly. The Supreme Court has ruled that the judge, or even the prosecutor, can force you to submit to a jury trial, even if you are desperately trying to waive it.
Is there any exception to that?
The only remote exception is if forcing you to face a jury would somehow legally deny you a fair trial, which is incredibly hard to prove.
So generally speaking, the prosecutor holds a veto over your request for a bench trial.
That's correct.
Wow. Okay, let's do our first MBE recap and lock this in before we move on.
Sounds good. Let's build the cheat sheet.
If I'm taking notes for this section, the absolute non-negotiables are, first, the magic threshold is strictly more than 6 months authorized by statute. Second, the aggregation trap. Do not add up multiple petty offenses. They don't count, no matter how high the total goes.
Spot on.
Third, for criminal contempt, we look at the actual sentence imposed, and appellate courts can magically fix a violation by trimming the sentence to 6 months.
Yep.
And finally, you don't have an absolute right to a bench trial. The prosecutor can force you in front of a jury.
That is a perfect synthesis. You've navigated the threshold.
Okay, so we've established who gets to walk through the doors into the courtroom. Now, let's look at the people sitting in the jury box.
The anatomy of the jury.
Right. What exactly does a constitutional jury look like? Because we always hear the phrase 12 angry men, or we see 12 people sitting in the box on TV.
Is 12 the magical constitutional number?
Yeah, is it?
It is not. The Constitution actually doesn't say a word about how many people have to be on a jury.
Really?
Yeah, for a long time, different states experimented with different sizes, but eventually the Supreme Court had to step in and set a floor.
Because if a jury gets too small, it stops functioning like a jury, right? If it's just 2 people, that's barely a conversation.
Exactly. The court ruled that a jury of fewer than 6 members is a denial of due process. 6 is the absolute constitutional floor.
So a 5-person jury is completely unconstitutional?
Yes.
But why 6? What is the psychology behind that specific number?
Well, the court reasoned that the whole point of a jury is to facilitate effective group deliberation. You need a diversity of perspectives.
You need people pushing back on each other's assumptions.
Right. And once you drop below 6 people, the group dynamics change, the diversity of thought evaporates.
And statistically, the risk of convicting an innocent person rises to an unacceptable level.
Exactly. So 6 is the baseline.
Okay, so we need at least 6 people. Now, what about their final decision? Do they all have to agree?
The unanimity question.
Because for a long time, I remember reading that in a few states, you can be sent to prison even if a couple of jurors disagreed. You could be convicted by a 10-2 vote.
That used to be true in states like Louisiana and Oregon. But this is an area where the constitutional landscape has experienced a massive seismic shift very recently.
Oh, really?
Yeah, the Supreme Court reversed decades of precedent in a landmark case called Ramos versus Louisiana. They held that a unanimous verdict is constitutionally required to convict a defendant of a serious offense.
So 100% agreement is mandatory across the board now?
Yes.
Oh.
It applies to both federal and state juries, whether it is a 6-person jury in a local state court or a 12-person jury in federal court.
Every single juror must vote guilty. If even one holds out, it's a hung jury.
Exactly.
Now, this brings up a massive logistical nightmare that I want you to explain.
Okay, hit me.
When the Supreme Court announced this new unanimity rule, there were already thousands of people sitting in prison in those specific states based on old, non-unanimous 10-2 verdicts.
Right.
What happens to them? Does the system just throw open the prison doors and give thousands of people new trials overnight?
This is one of the most difficult concepts in constitutional law, retroactivity. When the rules change, who gets the benefit?
Right. How do they decide?
The Supreme Court drew a very harsh line to prevent the system from collapsing. They distinguish between cases on direct review and cases on collateral review.
Okay, let's break those terms down. What is direct review?
Direct review means your case was still actively moving through the standard appeals process when the new rule was announced.
Like you were just convicted, your lawyer filed an appeal, and you were waiting for the appellate court to rule.
Exactly. If you were in that specific window, you get the benefit of the new unanimity rule. Your non-unanimous conviction is overturned, and you get a new trial.
But what if my standard appeals ran out 5 years ago?
Then your conviction is considered final. And if you try to challenge it years later through a special petition, like a writ of habeas corpus, that is called collateral review.
And does the new rule apply there?
The Supreme Court ruled that the new unanimity rule does not apply retroactively to cases on collateral review.
Wow. So I could be sitting in a cell next to a guy who committed the exact same crime. We both had 10-2 verdicts, but he gets a new trial because his paperwork was still on a desk.
And you stay in prison forever because your paperwork was filed away last year.
That is the brutal reality of finality in the justice system.
Yeah, the court reasoned that forcing states to retry thousands of decades-old cases where evidence is lost and witnesses are dead would just be an impossible burden.
So direct review gets the new rule. Collateral review does not. That is a stark distinction, but very important to remember for the exam.
Definitely.
Now, let's talk about the federal system specifically, because the sources point out a really interesting quirk. We know 6 is the constitutional minimum, but the federal rules require 12 members for a criminal trial, right?
Yes, the federal baseline is 12 jurors, and under the new rules, their vote must be completely unanimous.
But there is an exception in the federal rules that I find fascinating. Let me give you a scenario.
Okay, let's hear it.
We are in week 4 of a massive, complex federal trial. The jury finally goes back to the deliberation room. They are arguing, reviewing documents.
The classic tense deliberation scene.
Right. And then, suddenly, one of the jurors has a medical emergency. They get appendicitis and have to rush to the hospital.
Okay, bad news for that juror.
So do we really have to throw out 4 weeks of trial, declare a mistrial, and start over from scratch with 12 new people?
The federal rules say no, and it is a brilliant piece of pragmatism. If deliberations have already begun and there is good cause to excuse that one juror, like a medical emergency,
What happens?
the judge has the discretion to allow the remaining 11 jurors to continue deliberating.
And if those 11 reach a unanimous verdict, it counts.
It counts perfectly. It saves the system the massive expense of a mistrial while still staying well above that constitutional floor of 6 jurors.
Okay, time for MBE recap number 2. Let's update the mental cheat sheet.
Go for it.
The absolute minimum jury size is 6. Juries must be 100% unanimous to convict. That unanimity rule applies retroactively to direct review, but absolutely not to collateral review.
Correct.
And in federal court, 12 is the standard, but 11 can legally deliver a verdict if one drops out for good cause during deliberations.
Exactly. Now we have our parameters.
Yeah.
But that brings up the next massive hurdle. How do we actually fill those 6 or 12 seats?
Right. The Constitution can't possibly let the prosecutor just walk out into the hallway and pick their 6 best friends.
No, definitely not.
So how do we build this jury without violating the rights of the accused?
This process is incredibly heavily scrutinized because a jury is supposed to act as the conscience of the community.
Makes sense.
But to understand the rules, we have to make a very clear, highly testable distinction between 2 groups, the veneer and the actual jury.
Okay, the veneer. It sounds like a fancy architectural term, but we are talking about the jury pool.
Yes. The veneer is the large pool of potential jurors that get summoned to the courthouse on any given Monday morning.
Maybe it's 100 people sitting in a big room doing crossword puzzles.
Exactly. The Equal Protection Clause demands that this initial pool, the veneer, must represent a fair cross-section of the community.
Meaning you can't systematically exclude people.
Correct. The state cannot have a system that intentionally excludes specific, distinct groups, like racial minorities, women, or ethnic groups, from being called to jury duty.
So the pool has to be a reasonable snapshot of the county's demographics.
Yes.
Okay, so the waiting room has to be diverse. But what about the final 12 people who actually make it into the jury box? Do they have to be a perfect demographic mirror of the community?
No, and this is a massive trap for students.
Wait, really?
Yeah, the final seated jury does not need to be a proportional demographic mirror. The Supreme Court made this crystal clear.
So the Constitution guarantees a fair process for drawing the pool, but it does not guarantee proportional representation on the final panel.
Exactly.
Let me make sure I have this. The initial pool of 100 people needs to be fair. But by the time the lawyers finish interviewing them, asking them questions and striking people from the list, the final 12 people in the box could theoretically all be of one single demographic.
Yes, as long as the initial pool was fair and the lawyers didn't break any rules getting there, you can end up with a demographically homogenous jury, and it is perfectly constitutional provided the selection process itself was fair.
Which perfectly transitions us to how the lawyers shrink that pool of 100 down to 12. They use challenges.
Right, jury selection.
And the sources highlight something called peremptory challenges. I like to explain these as wildcard strikes.
Wildcard strikes is exactly how they function. During jury selection, which is a process called voir dire, both the prosecutor and the defense attorney are given a specific number of peremptory challenges.
And these allow the lawyers to strike or disqualify a potential juror without having to give any reason whatsoever.
Exactly. You don't need to show that the juror is related to the defendant or openly admits they are biased.
You just use your wild card. I don't like the way juror number 4 looked at my client. Strike.
Yep.
Juror number 7 crossed his arms when I spoke. Strike.
Exactly. It relies entirely on the lawyer's intuition, their reading of body language, their gut feeling.
But, and here's where constitutional law steps in to ruin the wildcard fun, there are absolute limits on these strikes.
Huge limits. This brings us to a concept highlighted with giant red flashing lights in our source material.
The Batson Challenge.
Yes, Batson.
This is a massive rule. What exactly is Batson?
Batson is the landmark case that declared you cannot use your wildcard strikes to discriminate.
Okay, how does that work?
The Equal Protection Clause absolutely prohibits lawyers from exercising peremptory challenges based solely on race, ethnicity, or gender.
So you cannot look at a black juror or a female juror or a Hispanic juror and strike them simply because of their demographic, assuming they might vote a certain way. Now, here's where it gets really interesting. When people think of Batson, they usually picture a racist prosecutor trying to strike all the minority jurors to hurt a minority defendant.
That's the classic scenario, yeah.
But our notes explicitly point out that the defendant is not allowed to discriminate either.
That is a critical point. The Equal Protection Clause doesn't just protect the defendant, it protects the juror's right to participate in the democratic process.
Wow, I never thought of it that way.
Yeah, so the defense attorney cannot use their wildcard strikes to systematically remove all the white jurors or all the female jurors either.
Okay, that makes sense.
And furthermore, a defendant has standing to challenge the prosecutor's discriminatory strikes, even if the defendant is not a member of the excluded group.
Wait, really? So a white defendant can object if the prosecutor is illegally striking black jurors?
Absolutely, because the harm is being done to the integrity of the justice system and to the jurors themselves.
Okay, so you can't strike someone based on race or gender. But if there are wildcard strikes, and you technically don't have to give a reason, how on earth do you prove the lawyer is secretly being discriminatory?
It's tough.
Right. If I'm a prosecutor, I could just say, I struck him because he wasn't paying attention, when really I struck him because of his race. How does a judge police the inside of a lawyer's mind?
This is exactly why the Supreme Court created the three-prong Batson test.
Ah, the 3 prongs.
Yeah, it is a very specific, rapid-fire, burden-shifting dance that happens right there in the middle of the courtroom. Let's actually walk through how this plays out.
Okay, let's role play this. I'll be the defense attorney. Step 1 of the test. What do I do?
Prong 1. The moving party, you, the defense attorney, has to establish a prima facie case of discrimination. You have to point out a suspicious pattern.
So I stand up and say, Your Honor, I object under Batson.
Yeah.
The prosecutor has used their last 4 wildcard strikes to remove every single Hispanic juror from the panel.
Right.
This establishes a clear pattern that looks like racial discrimination.
Perfect. You've shown the pattern. Now the burden shifts.
Okay, to the prosecutor.
Yes. Prong 2. The party who exercised the strike, the prosecutor, now has to provide a race-neutral or gender-neutral explanation for the strike. They are forced to articulate a reason.
So the prosecutor says, Your Honor, it had nothing to do with race. I struck juror number 4 because he said he had a bad experience with police officers in the past.
Okay, good reason.
And I struck juror number 7 because she was falling asleep during my questioning.
Exactly. And here is the secret to prong 2. The bar for this race-neutral reason is incredibly low.
Really? How low?
It doesn't have to be a persuasive reason or even a good reason. It just has to be a reason that is structurally independent of race or gender.
So what's an example of a silly reason that still passes?
The Supreme Court literally said a prosecutor could say, I struck him because he has long, unkempt hair and a mustache. As long as it's not race or gender, it technically passes prong 2.
Wow. Okay, so if the bar is that ridiculously low, How does the defense ever win a Batson challenge? A lawyer can just make up any silly excuse.
That brings us to the final step, prong 3.
Okay, prong 3.
The burden shifts back to you, the defense attorney, to prove that the prosecutor's race-neutral reason was actually a pretext for discrimination.
A pretext. So I have to prove to the judge that the prosecutor is lying and that the strike was indeed motivated by purposeful discrimination.
Precisely.
Okay, so this is where I look at the rest of the jury. I'd say, Your Honor, the prosecutor claims he struck the Hispanic juror because she was falling asleep. But look at juror number 12, a white juror who's been openly snoring for 10 minutes, and the prosecutor didn't strike him.
Exactly. You compare the struck jurors to the kept jurors to expose the lie.
The sleeping excuse is just a pretext. The real reason is race.
Yes. And then the judge looks at all the evidence, looks at the lawyer's demeanor, and makes the final call on whether there was intentional discrimination.
The ultimate burden of persuasion always rests with the person attacking the strike. You got it.
That is a brilliant breakdown of how the mechanics actually work. Now, before we lock in the recap for this section, there's one more detail about these wildcard strikes.
Okay, what is it?
What happens if a judge messes up? Let's say I'm the defense attorney. I try to use my wildcard strike. The prosecutor objects, claims I'm violating Batson. The judge agrees with the prosecutor and forces me to keep the juror.
Okay, you lose your strike.
But a year later, an appeals court reviews the transcript and says the judge was wrong and I should have been allowed to use my strike. I was unfairly robbed of my wild card. Is my conviction automatically overturned?
No. And this introduces a vital concept, the harmless error doctrine.
Harmless error, okay.
The Supreme Court ruled that the loss of a peremptory challenge does not in itself violate your constitutional right to an impartial jury.
But I didn't get to use my strike.
Remember, wildcard strikes are creations of state law or procedural rules. They are not strictly guaranteed by the Constitution itself. So the Constitution guarantees an impartial jury, not a jury where you got to use all your wild cards.
Right. So losing one isn't a constitutional crisis that requires a new trial.
So how do states handle it?
The Constitution allows states to choose how to handle this mistake. A state can decide to use automatic reversal if a judge mistakenly denies a strike.
Well, they don't have to.
Right. A state can also choose to apply harmless error review, meaning the appeals court looks at the case and says, yes, the judge messed up by denying your wildcard strike, but we looked at the final jury that actually heard your case, and they were perfectly fair and impartial.
Therefore, the judge's error was harmless, and your conviction stands.
Exactly.
That makes total sense. The focus is on the final fairness, not the procedural game.
Yeah.
Okay, MBE recap number 3. Let's synthesize this.
Go ahead.
If I'm looking at a fact pattern about building the jury, I need to remember first, the veneer pool must be a fair cross-section. But the final seated jury does not have to be a demographic mirror. Second, the Batson rule stops both prosecutors and defense attorneys from striking based on race or gender.
Both sides, yes.
Third, the 3-step dance. Show the pattern, give a race-neutral excuse, and then prove the excuse is a lie.
Perfect.
And fourth, mistakenly losing a wildcard strike can be treated as a harmless error by the state.
Spot on. We finally have our jury built and seated in the box.
So we move to the trial environment. The jury is watching, the judge is presiding. Now we have to look at the rules governing their decisions.
Right, and specifically how the jury's fact-finding interacts with the judge's sentencing power.
But first, we need to look at the highest stakes scenario possible. Capital punishment. The death penalty.
The ultimate penalty.
How does the jury selection process change when the defendant's life is literally on the line?
It introduces a very specific type of for-cause challenge. We just talked about wildcard strikes, but lawyers can also strike a juror for cause if the juror has an actual proven bias that prevents them from being fair.
Like in a standard trial, maybe a juror is related to the victim.
Exactly. But in a capital case, the prosecutor is looking for a very specific mindset. They want a jury that is at least theoretically willing to consider imposing the death penalty.
Right. If you have a juror who is a strict pacifist and morally opposed to the death penalty under any and all circumstances, they aren't going to vote for it, no matter how horrific the evidence is.
Right. So prospective jurors who are opposed to the death penalty can be removed for cause. But the standard is incredibly strict.
How strict?
They can only be removed if their views are so strong that they would prevent or substantially impair the performance of their duties at the sentencing phase.
Substantially impair. That's the key phrase.
Yes.
But what if the judge gets this wrong? What if the judge excludes a juror who was just a little hesitant? Someone who said, I don't like the death penalty, but if the law requires it, I'll do my duty.
Okay, but the judge kicks that person off the jury by mistake.
Yeah, does the harmless error rule we just talked about apply?
Absolutely not. And this is a massive distinction to keep straight for the exam. An improper exclusion of a juror from a jury that ultimately imposes a death sentence is subject to automatic reversal.
Wow, automatic reversal.
Yes. If the judge improperly removes a juror who merely had qualms about the death penalty but was not substantially impaired, and that defendant gets a death sentence, that sentence is automatically thrown out.
So there is no harmless error when life is on the line. The stakes are just too high.
Exactly. That is a sharp contrast to the peremptory challenge rule.
It really is. Okay, let's move from capital punishment to standard sentencing, because we need to talk about one of the most important rules in modern criminal law, the Apprendi rule.
Apprendi is huge.
This rule is fundamentally about the separation of powers within the courtroom. It defines exactly what the jury is allowed to do versus what the judge is allowed to do.
Right.
I love explaining this rule with an analogy. Think of a criminal trial as a car driving down the highway. The jury is the engine block.
Okay, I like where this is going.
They drive the facts. They decide what happened, who did it, and whether it was proved beyond a reasonable doubt.
And the judge.
The judge is the suspension, the steering wheel, and the brakes. They guide the process, keep it on the road, and apply the law.
That makes sense.
But the Apprendi rule essentially says the judge cannot reach under the hood and slap a turbocharger onto the engine based on their own secret findings.
That is a brilliant way to conceptualize it. Let's ground that turbocharger analogy in the actual legal rule.
Okay, what's the strict definition?
The rule states that any fact, other than a prior conviction, that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt.
Let's run a hypothetical to see the mechanics of this. Let's say I'm convicted of simple assault. The statute clearly says the maximum sentence for simple assault is 2 years in prison.
Okay, 2 years max.
The jury hears the evidence, they find him guilty, and they go home. Right. But a week later, at the sentencing hearing, the judge looks down at me and says, you know what? I listened to the testimony, and I personally think this assault was actually a hate crime.
Oh, wow.
And under our state laws, a hate crime enhancement bumps the maximum sentence up to 10 years. So I am unilaterally giving you 10 years.
And that right there is a blatant, unconstitutional violation of the Apprendi rule.
Because the judge just slapped a turbocharger on the sentence.
Exactly. Based on a fact that it was a hate crime that the jury never decided, the judge unilaterally increased your sentence beyond the 2 years statutory maximum that the jury's verdict authorized.
So if the prosecutor wanted to give me 10 years, what was the proper mechanism?
They had to put the hate crime allegation in the original indictment, present evidence of it to the jury during the trial, and have the jury decide beyond a reasonable doubt that it was indeed a hate crime.
So the jury, the engine, must find all the facts necessary to authorize the elevated sentence.
Yes. The judge cannot bore out the cylinders alone.
That makes perfect sense. It protects the defendant's right to have a jury judge every single aspect of the crime that leads to their punishment.
It does.
But you mentioned one glaring exception in the rule. Other than a prior conviction, why are prior convictions excluded from this turbocharger rule?
It is a purely pragmatic exception based on the history of the system. The fact of a prior conviction has already gone through the judicial wringer.
What do you mean?
It was already subject to the right to a jury trial, proof beyond a reasonable doubt, and all those constitutional protections years ago when it happened.
Oh, I see.
So a judge today can look at your criminal record and say, because you have 3 prior convictions, I am applying a habitual offender enhancement and increasing your sentence.
And the judge can do that without asking the current jury to verify the old convictions.
Exactly. The old convictions already earned their constitutional stripes.
Got it. Okay, the last topic in this trial environment section is a real mind-bender. It's the concept of inconsistent verdicts.
Oh yeah, this rule drives people crazy because it defies strict logical reasoning.
Set this up for us. What exactly is an inconsistent verdict?
Imagine a defendant is charged with 2 intimately related crimes. Crime A is robbing a bank. Crime B is a compound charge using a firearm during the commission of a bank robbery.
Okay, so crime A is the predicate offense for crime B.
Exactly. Logically, physically, it is impossible to be guilty of crime B unless you are also guilty of crime A.
Right. You can't use a firearm during a bank robbery if you didn't commit the bank robbery in the first place.
Exactly. But let's say the jury deliberates for 3 days. They come back into the courtroom, hand the verdict form to the judge, and the judge reads it aloud.
And what does it say?
Charge A, robbing a bank. Not guilty. Charge B, using a firearm during the commission of a bank robbery. Guilty.
That is completely, entirely illogical. It makes zero sense.
It makes no sense at all.
As a defense attorney, I would be leaping out of my chair, screaming, "You have to throw out the conviction. The jury just officially declared he didn't rob the bank, so he legally cannot be guilty of the firearm charge."
Any defense attorney would.
Does the judge throw it out?
No. And that is the established rule of law. If a jury renders an inconsistent verdict, the guilty verdict stands. It is not reviewable on the grounds of inconsistency.
But why? How does the justice system, which is built on logic and reason, tolerate something so blatantly contradictory?
Because the Supreme Court recognizes that the jury room is a human black box.
A human black box.
Yeah. When a jury delivers an inconsistent verdict, it is almost always a product of leniency, compromise, or sheer exhaustion.
So they might have known he was guilty of both.
Right. Maybe they knew the defendant was guilty of both charges, but they felt bad for him, so they compromised by acquitting him of the main charge to save him some prison time, but convicted on the lesser charge.
Or maybe it's a Friday afternoon, they are exhausted, and they just split the baby to go home.
Exactly, but we don't know why they did it.
We could never know.
Right. And the court says that the prosecution is already heavily penalized by the illogical acquittal. They can't appeal the not guilty verdict because of double jeopardy rules.
Ah, true.
So the court reasons it would be incredibly unfair to the prosecution to also throw out the guilty verdict just because the jury was trying to be lenient to the defendant.
The system simply accepts the inconsistency as a quirky byproduct of human juries.
Exactly.
That is fascinating. The law actively chooses to respect the messy human element of the jury room over strict mathematical logic.
It does.
Okay, let's synthesize this trial section.
Yep.
MBE recap number 4.
Let's lock it in.
If I'm studying this, first, in capital cases, improperly excluding a juror who was just hesitant about the death penalty leads to an automatic reversal of the sentence. No harmless error.
Correct.
Second, the Apprendi rule. Any fact other than a prior conviction that increases the sentence beyond the statutory max must be found by a jury. The judge cannot turbocharge the sentence alone.
Nailed it.
And third, completely ignore inconsistent verdicts. They are perfectly legal and unreviewable.
Exactly. You survived the trial.
But here is the massive reality check. We have spent all this time talking about trials, the juries, the Batson strikes, the verdicts, the cross-sections.
Yeah.
But the vast, vast majority of criminal cases in the real world never go to trial. They bypass this entire system and end in a guilty plea.
Yes. The plea system is the actual functioning engine of the American criminal justice system.
Right.
But because a guilty plea is a complete and total waiver of your most fundamental constitutional rights, the Supreme Court has laid down very strict procedural rules for how they must be conducted.
You can't just sign a piece of paper in a hallway and go to prison.
No, absolutely not.
Let's start with the baseline checklist for a valid guilty plea.
Yeah.
What makes a plea constitutional?
Well, a guilty plea is a massive waiver. You are giving up the Fifth Amendment privilege against self-incrimination, the Sixth Amendment right to a trial by jury, and the right to confront your accusers face-to-face.
That is a lot to get up all at once.
Because you are surrendering so much power to the state, the plea must be strictly knowing and voluntary. And the system cannot just assume you know what you are doing.
So it must be explicitly established on the record.
Right. Meaning the judge has to physically speak to the defendant in open court with a court reporter typing down every word to verify this.
What exactly is the judge checking off on this list?
The judge must determine that the defendant understands 3 core things.
Okay.
First, the nature of the charges and their essential elements. Second, the consequences of the plea, meaning the maximum and minimum possible sentences, and sometimes severe collateral consequences like deportation if you aren't a citizen.
And the third?
And third, the specific constitutional rights that the defendant is permanently waiving.
Now, let me push back on that first point, the nature of the charges. Does the judge have to sit there on the bench and deliver a 30-minute law school lecture explaining every single intricate element of the crime to the defendant.
No, and that is a classic trick question on exams.
Oh, really?
Yeah, the Supreme Court has clarified that the judge does not personally need to explain each element. It is completely sufficient if the record shows that the defendant's defense counsel explained the nature and elements of the crime to them privately beforehand.
The judge just needs to ask, did your lawyer explain the charges to you, and do you understand them?
Exactly. If the defendant says yes, the checklist is satisfied.
Okay, so that's a standard guilty plea. I did it. I understand my rights. I accept the punishment.
Right.
But what if I want to accept the punishment, but I absolutely, vehemently refuse to admit that I actually committed the crime?
Yeah.
This brings us back to the paradox I mentioned at the very beginning of the deep dive, the Alford plea.
Yes. It is one of the most brilliant, pragmatic, and perplexing pieces of law in the entire system.
Explain the mechanics of this to me, because when you explain this to lay people, their heads just explode. How can you plead guilty while actively telling the judge to their face that you are innocent?
It seems impossible, right?
Isn't the very definition of pleading guilty admitting guilt?
You would naturally think so, but the Supreme Court looked at this deeply in a case involving a man named Alford.
What happened with Alford?
Alford was facing a potential death penalty if he went to trial. He maintained he was innocent, but he had terrible, overwhelming evidence against him.
So he was in a really bad spot.
His lawyer looked at the facts and told him he was almost certainly going to be convicted by a jury and executed. The state offered him a plea deal, plead guilty to second-degree murder, and we will guarantee you a life sentence instead of death.
A huge choice to make.
Right. Alford took the deal to save his own life. But he stood up in open court and said, I didn't do it, but I'm pleading guilty because I don't want to die.
And the Supreme Court reviewed that and said it was perfectly fine.
Yes. The court reasoned that the Constitution does not strictly require an express admission of guilt as a prerequisite for a judge to impose a criminal penalty.
What does the Constitution care about then?
It cares that the defendant is making a rational, voluntary choice between the alternatives available to them. Alford rationally looked at the overwhelming evidence, recognized the extreme risk of the death penalty, and voluntarily chose the certainty of a lesser sentence.
As long as the plea is voluntary and intelligent, maintaining your innocence does not invalidate it.
Exactly.
But there has to be a safeguard, right? Otherwise, I could just walk into court tomorrow and plead guilty to assassinating Abraham Lincoln just because I feel like it.
Exactly. You can't just plead guilty to fiction, and that safeguard is built into the rules. Before accepting any guilty plea, but especially an Alford plea, the judge must ascertain that there is a solid factual basis for the plea.
Factual basis, meaning what?
The prosecutor still has to stand up and summarize the evidence. They have to say, Your Honor, if this case went to trial, we would present witnesses X, Y, and Z who would testify to these specific facts showing the defendant committed the crime.
So there has to be enough objective evidence on the record to show that a jury could easily convict the defendant.
Yes.
Fascinating. So you maintain your innocence, but you legally acknowledge that the state has enough facts to bear you at trial.
Precisely.
Okay, let's talk about the negotiation process that leads to these pleas. The plea bargain. How should we conceptualize these negotiations?
The best mental model for a plea bargain is a contract. It is a strict negotiation between the prosecutor and the defendant.
Like, I will drop these 3 minor charges if you plead guilty to this major one.
Or, I will recommend a 5-year sentence to the judge if you save the state the time and expense of a 3-week trial.
But do I have a constitutional right to get a plea bargain? If I'm a first-time offender, can I demand a deal?
No. There is absolutely no constitutional right to a plea bargain. The prosecutor has total, unreviewable discretion to say, no deals for you. We are going to trial on the maximum possible charges.
Okay, but what if the prosecutor uses extreme pressure tactics during the negotiation?
What kind of tactics?
What if they say, listen, we've currently charged you with a minor felony. If you don't sign this plea deal today, I'm going to go back to the grand jury tomorrow and indict you on a massive life sentence charge.
Right, threatening higher charges.
Isn't that prosecutorial vindictiveness? Isn't that the state actively punishing me just for exercising my constitutional right to a trial?
You are echoing exactly what defense attorneys argued for years. It feels like extortion.
It really does.
But the Supreme Court said no. They ruled that in the give and take of plea bargaining, there is no element of unconstitutional punishment or retaliation so long as the accused is free to accept or reject the offer.
So the prosecutor is allowed to use the threat of much more serious charges as leverage to secure a plea.
Yes, provided the prosecutor actually has probable cause to bring those more serious charges. It's just hardball contract negotiation.
Hardball negotiations. Now, speaking of contracts, in a normal business contract, if one side intentionally hides crucial information from the other side, it's called fraud, and you can rip the contract up.
That's true.
So in a plea bargain, does the prosecutor have to show the defense all their cards before the defendant signs away their life?
This is a massive, highly testable rule for the MBE, and the answer is no.
Wow, really?
The Supreme Court held in a case called Ruiz that the prosecution is not required to disclose impeachment information prior to a plea agreement.
Let me make sure I understand impeachment information. That means evidence that would attack the credibility of the state's witnesses, right?
Exactly. Evidence that shows their star witness is a chronic liar or has a terrible memory or was paid off.
Wow. Let me get this straight. The prosecutor offers me a deal. They secretly know that their star witness is a known perjurer who changes their story every 5 minutes. They don't tell me that.
Right.
I look at the charges, assume they have a strong case, and take the plea deal. When I find out a year later that they hid the fact their witness was garbage, I can't tear up the plea bargain.
You cannot. The court ruled that failure to disclose impeachment information does not render a plea involuntary.
But why?
Because a plea agreement is fundamentally a waiver of a trial. And the right to impeach witnesses is a right that inherently belongs to the trial phase. You gave up the trial to get a lighter sentence, so you gave up the right to complain about the impeachment evidence.
That feels incredibly harsh and tilted toward the state. But I guess it strongly reinforces the absolute finality of plea agreements.
It does. It's all about finality.
Okay, let's synthesize this plea section. MBE recap number 5.
Let's do it.
First, pleas must be knowing and voluntary. The judge must confirm on the record that the defendant understands the charges, consequences, and waived rights, though the defense counsel can be the one to explain the specific elements.
Correct.
Second, the Alford plea. You can constitutionally plead guilty while openly maintaining your innocence as long as it's a rational choice and there's a factual basis on the record.
Yes.
Third, plea bargains are just contracts. There's no right to one. Prosecutors can legally threaten heavier charges as leverage.
And crucially,
the prosecution does not have to disclose witness impeachment evidence before you sign the deal under the Ruiz rule.
perfectly summarized.
So we've talked about what happens at a trial, and we've talked about what happens if you take a plea. But what happens during the agonizing waiting period?
The ticking clock.
Right. If I refuse a plea deal, I have to wait in a cell or on bail for my trial to start. How long is too long? When does the state run out of time?
The Constitution guarantees the right to a speedy trial, but unlike the 6-month rule for juries, the speedy trial right is one of the most flexible, contextual, and frustrating rights we have.
Why is that?
There is no hard mathematical deadline in the Constitution.
First of all, when does the clock even start ticking? If the police are secretly investigating me for 5 years, gathering evidence, trailing my car, before they finally arrest me, does that 5-year delay violate my speedy trial rights?
No, that is considered pre-accusation delay. The Sixth Amendment speedy trial right doesn't even attach until you are officially accused.
Meaning when?
That means the clock starts at the exact moment of your arrest or when formal charges, like an indictment, are filed against you, whichever comes first. Before that moment, the speedy trial clock is at 0.
Okay, so I get arrested. The clock starts. Fast forward 3 years. I'm still sitting in a county jail waiting for my trial. My lawyer files a motion demanding the judge dismiss the case for violating my speedy trial rights. If there's no hard mathematical deadline, how does the judge decide if 3 years is unconstitutional?
The judge applies a famous 4-factor balancing test from a case called Barker v. Wingo.
4 factors.
Yeah. The court dumps these 4 factors into a cauldron, stirs it around, and makes a subjective decision on whether the state made a diligent, good faith effort to bring you to trial.
Okay, let's walk through the 4 factors. What is the judge looking at?
Factor 1 is simply the length of the delay. This acts as a triggering mechanism.
Like if it's really short, they don't bother.
Exactly. If the delay is only a month or 2, the judge doesn't even bother looking at the other factors. But if it's a year or more, it's considered presumptively prejudicial, and the judge moves down the list.
Okay, what's factor 2?
Factor 2 is the reason for the delay. This is where the judge asks, who is actually at fault here?
Did the state delay the trial because a key witness was in a coma and couldn't testify?
Right. That's a valid, understandable reason. But did the state delay just to mess with you and keep you locked up? That weighs heavily against the state.
What if the delay was caused by my own lawyer? What if my public defender is completely overworked, handling 100 cases, and they keep asking the judge for continuances because they haven't had time to read my file?
That is a harsh reality of the system and a great nuance to understand for the test.
Does it count against the state?
Delay caused by your assigned attorney is generally attributable to you, the defendant, not the state. The court views your lawyer as your agent.
So if my lawyer delays, it hurts my speedy trial claim.
Exactly. The only exception is if there is a massive systemic breakdown in the public defender system that the state completely failed to fix. But generally, if your lawyer asks for more time, the clock stops ticking against the state.
Okay, so that's length and reason. What are the last two factors?
Factor 3 is the defendant's assertion of the right.
Did I ask for a trial?
Exactly. Did you sit quietly in your cell for 3 years without saying a word, or were you banging on the bars every single month, filing motions, and actively demanding a trial?
If you didn't assert the right, the judge assumes you were perfectly happy to wait.
Precisely. And factor 4 is prejudice to the defendant. Did the delay actually hurt your ability to defend yourself?
Like, did your alibi witness die during the 3 years?
Right. Or did the security camera footage get taped over while you were waiting?
So the judge balances all 4 of those. But here is the critical question. What happens if the judge actually decides the state crossed the line?
What's the remedy?
Yeah, let's say the state delayed for 4 years for no good reason. I demanded a trial every day, and my witnesses died. The judge rules my speedy trial right was violated. Do I just get a stern apology from the prosecutor and a rush trial tomorrow morning?
No. And this is why this right is so heavily litigated. The remedy for a Sixth Amendment speedy trial violation is the most severe ultimate remedy in all of criminal law.
What is it?
It is the complete dismissal of charges with prejudice.
With prejudice.
Yeah.
Meaning the case is completely dead.
Exactly. The prosecution cannot ever bring those charges back. They can't refile them. The case is over, and you walk free,
Right.
regardless of how guilty you might actually be.
Wow.
Because the remedy is so extreme, judges are incredibly hesitant to actually find a speedy trial violation unless the state's behavior was egregious.
That makes sense. The stakes are literally all or nothing. Now, while we are looking at the clock, let's briefly look at the doors of the courtroom.
The public trial, right?
Right, the Sixth Amendment says trials must be public. But what if a trial is going to be a massive, sensationalized media circuit?
A total circus, yeah.
What if a defendant begs the judge to lock the doors, kick the reporters out, and close the trial to the public to ensure the jury isn't influenced? Can the judge just say, sure, it's your trial, we'll lock the doors?
No. And this is a fascinating area where two constitutional amendments violently crash into each other. The defendant has a Sixth Amendment right to a fair trial, but the public and the press have a First Amendment right of access to watch the courts operate.
Ah, the First Amendment.
The Supreme Court has established in cases like Press Enterprise that trials must be open to the public unless there is a substantial proven likelihood of prejudice to the defendant.
So the court rarely closes proceedings completely.
Very rarely, because that First Amendment right of the public to watch the justice system function is the ultimate transparency check against government corruption.
It prevents secret star chambers. Okay, let's lock in the rules for the ticking clock with MBE recap number 6.
Let's do it.
First, the speedy trial clock starts at arrest or formal charge, whichever is first.
Correct.
Second, the Barker v. Wingo balancing test has 4 factors: length of delay, reason for delay, defendant's assertion of the right, and prejudice to the defense.
Spot on.
Third, the ultimate and only remedy for a speedy trial violation is dismissal of the charges with prejudice. And fourth, trials are fundamentally open to the public. A defendant cannot easily demand a closed trial because of the public's First Amendment rights.
Excellent. We are on the final stretch. We are inside the courtroom.
We've finally reached the trial itself. The jury is watching. The clock is ticking. The doors are open. What are the strict boundaries for the referee, the judge, and the opposing captain, the prosecutor?
Well, the overarching constitutional umbrella here is due process, which demands fundamental fairness. And that fairness has to start with the judge.
An impartial judge.
Right. A judge must possess neither actual nor apparent bias. If the judge has a financial interest in the outcome of the case, or a personal vendetta against the defendant stemming from an extrajudicial source, meaning something outside the courtroom, like a prior business dealing, they must recuse themselves.
That is the basic baseline. You need a neutral referee.
Absolutely.
But the really meaty testable rules apply to the prosecutor. because the prosecutor wields the immense terrifying power of the state. So what are the absolute thou shalt nots for the prosecution?
There is a long list of behaviors classified as prosecutorial misconduct. The prosecutor cannot make material misstatements of law or fact to the jury.
Okay, no lying.
They cannot try to secretly elicit information from the defendant without their defense lawyer present. And they cannot express personal opinions about the defendant's guilt.
So a prosecutor can't stand up in closing arguments, point at the defendant, and say, "Ladies and gentlemen of the jury, I have been doing this for 20 years, and I personally believe this man is a cold-blooded killer."
Exactly. They must rely entirely on the evidence presented, not their personal authority or experience.
That makes sense.
But the most critical thou shalt not, and a huge constitutional rule, is that they cannot comment on the defendant's failure to testify.
Because of the Fifth Amendment.
Yes. The Fifth Amendment gives you the absolute right to remain silent. If you choose not to take the witness stand, the prosecutor cannot point at an empty chair and say, "If he was really innocent, why didn't he get up there and explain himself to you?"
That is an automatic foul.
A huge foul. But the biggest, most intensely tested rule for prosecutors is all about evidence. Let's unpack the Brady Rule.
Yes, the Brady Rule. This is a big one.
Brady is the absolute bedrock of discovery in criminal law. The rule states that due process requires the prosecution to turn over all evidence in its possession that is favorable to the accused.
Meaning it is either exculpatory or impeaching.
Right, if that evidence is material to guilt or punishment.
Let's use an analogy to understand the mechanics here.
Yeah.
Imagine the trial is a high-stakes game of poker.
A poker game, okay.
But the rules of this specific poker game say that the dealer, the prosecutor, legally has to show you any cards in their hand that prove you're holding the winning hand.
I like this.
And if they hide those cards, win the pot, and you find out later, you get a completely new game.
That is exactly how it functions. The prosecutor's job, constitutionally, isn't just to win convictions, it is to seek justice.
So if they have a police report hidden in a file where an eyewitness says the bank robber was 6 feet tall and the defendant sitting at the table is 5'2", the prosecutor must hand that report to the defense.
That is exculpatory evidence. It tends to prove innocence.
But the rule says they only have to hand it over if it is material. What does material actually mean in the context of a trial?
Evidence is material if there is a reasonable probability that disclosure would have changed the outcome of the proceeding.
A reasonable probability.
Right, defined as a probability sufficient to undermine confidence in the outcome.
So if the prosecutor hides a piece of evidence, but it's just a tiny, irrelevant detail, like a witness got the color of the getaway car's hubcaps wrong and it wouldn't have swayed the jury anyway, it's not a Brady violation that gets the conviction thrown out.
Correct. The system doesn't throw out a conviction over harmless trivia.
But if they hide the only police report that proves the defendant had an ironclad alibi, that completely undermines confidence in the guilty verdict.
That is material, and the defendant is entitled to a new trial.
Now, what if the police had that exculpatory report, but they accidentally dropped it in a puddle and ruined it before trial?
Oh, destruction of evidence.
Yeah, or what if they lose a piece of evidence before the defense even gets to test it?
This brings in a separate but related rule. If the police destroy evidence that would have been useful to the defendant, it only violates due process if the police acted in bad faith.
Bad faith.
Yeah.
So malice, intentional destruction to hurt the defendant.
Yes. If a police evidence locker accidentally floods and ruins a box of documents, or if they routinely purge an old storage room after a year without realizing the evidence was still needed for an appeal, there is no due process violation.
Because it wasn't malicious.
Exactly. The Constitution does not require the police to perfectly preserve every single item indefinitely if it wasn't clearly exculpatory to begin with. The defense has to prove the police destroyed it intentionally in bad faith to sabotage the trial.
The bad faith requirement is a massive hurdle for the defense, but an easy rule to remember for a test.
Very true.
Okay, let's bring it home with our final MBE recap, number 7. The rules of fair play.
Let's do it.
First, prosecutors absolutely cannot comment on a defendant's failure to testify.
Correct.
Second, the Brady Rule. Prosecutors must act like honest poker dealers and disclose evidence that is favorable to the accused and material to the outcome.
Yes.
Third, material means a reasonable probability it would have changed the verdict.
Exactly.
And fourth, the police only violate due process by destroying useful evidence if you can prove they did it in bad faith.
A perfect summary of the rules of the game.
And there we have it. We have navigated the entire constitutional maze.
It was a long journey.
From the bouncer at the door checking for a 6-month sentence, to the psychology of the 6-person jury, the wildcard strikes and the Batson dance, the turbocharged sentences of Apprendi.
The complex, contradictory contracts of the Alford plea.
The ticking clock of speedy trials, and the mandatory poker reveals of Brady. I want to thank our expert guide for walking us through this incredibly dense constitutional thicket and explaining the hidden mechanics behind the rules.
It was a pleasure dissecting it with you.
If you are prepping for the MBE, you just absorbed a massive amount of highly testable material.
You really did. And as we wrap up, I want to leave the listener with a final thought, connecting a few of the seemingly contradictory dots we discussed today.
Okay, lay it on us.
We spent most of our time detailing the intricate, beautiful protections of a constitutional jury trial. The forced unanimity, the fair cross-section of the community, the strict Brady disclosure rules designed to find the absolute truth.
Right. It's the gold standard of justice.
But then we looked at the plea bargaining system. We saw that under the Ruiz rule, the prosecution does not have to hand over witness impeachment evidence during a plea negotiation.
They can legally hide the flaws in their case to secure a conviction.
And when we acknowledge the reality that the vast, vast majority of criminal cases in America end in plea bargains, not trials, this raises a deeply important question.
Oh, this is a fascinating tension.
Are we creating a two-tiered justice system? On one tier, you have the idealized trial, a constitutional search for truth, where all cards are on the table, the jury is carefully curated, and every right is protected.
And on the other?
On the second tier, the reality for most people, you have an administrative machine of plea bargaining driven entirely by efficiency, where the truth can be legally obscured, leverage is used like a weapon, and constitutional rights are traded away like commodities.
Wow.
Which tier represents our actual system of justice?
That is a lingering, provocative thought to chew on. Are we prioritizing systemic efficiency over the absolute truth? Thank you for jumping into this deep dive with us, everyone. We'll see you next time.